You think a girl who learned law from a second-hand textbook can argue a case I wrote? That got a big laugh. The whole room, 400 people cracking up like it was a comedy show, not a moot court competition at the Nigerian law school in Lagos. Professor Richard Harmon stood at the podium, his voice rolling across the chamber like he owned the air inside it. I once gave that same problem to my house cat, he said, leaning into the microphone. She walked away after 2 minutes. At least she knew when something was above her. The room lost it all over again. Laughter bouncing off the marble walls, off the portraits, off the high ceiling that was designed to make voices sound important. Claire Adeyemi didn't flinch. She sat straight in her seat, both hands flat on the desk in front of her, and looked directly at Professor Harmon. When the laughter died down enough for her voice to carry, she said, "Are you finished? Because I would like to see the brief now." Harmon smiled slowly, the smile of a man who had never been surprised by anything in 30 years. "Fine," he said. "Let's see how fast you fold." She didn't fold. She made every single person who laughed that day choke on it, starting with him. To understand what happened that morning inside that chamber, you need to understand the room Claire Adeyemi walked into. The Harmon-Briggs National Moot Court Invitational, held every year at the Nigerian Law School, Lagos campus. 22 years running, founded, funded, and chaired by one man, Professor Richard Harmon, Senior Advocate of Nigeria, former Attorney General, author of the most widely assigned legal textbooks in Nigerian universities. This was not some interdepartmental debate. Past winners went on to the Supreme Court Bar, the International Criminal Court, senior partnerships at the most powerful law firms on the continent. Winning this competition did not just look good on a resume. It launched careers, it changed family trees. And for 22 straight years, Richard Harmon decided who got that chance. Hello friends, welcome. Before we begin, please like this video, share it, and subscribe to the channel. Also, let us know in the comments where you are watching from. Are you watching from the United States, the United Kingdom, Canada, Nigeria, Ghana, South Africa, or somewhere else in the world? We would love to know. And when you finish watching, tell us one thing you learned from the video. The competition hall seated 400 people. Break time 05's dark oak paneling on every wall, portraits of past winners lining the corridor outside. 21 years of champions, every single one from a private university or a federal government college. Not one from a state school. Not one from anywhere that didn't already carry the weight of prestige before the competition began. The judges sat at an elevated bench, elevated on purpose. The way courtroom benches are elevated on purpose, to remind everyone below that looking up is the natural direction. 5 panelists. Harmon in the center chair. His bench was wider than the others. His nameplate was bigger. Even the lighting above him was slightly brighter, the way you'd arrange a stage for someone who had never learned to share one. The audience was exactly what you would expect. Law students in pressed blazers from the University of Lagos, the University of Ibadan, Babcock, Covenant. Their professors in the third row, already networking with their eyes. Senior advocates standing against the wall, arms folded, watching for talent to recruit. A live stream running. Journalists from 2 legal journals. A camera crew from a satellite news channel covering the event as part of a segment on Nigeria's brightest young legal minds. And then there was Claire Adeyemi, 19 years old, born and raised in Ajegunle, Lagos. One of the most overlooked neighborhoods in a city that is very good at overlooking people. She lived with her mother, Doris, and her younger twin brothers in a single-story flat on a street where the drainage flooded every rainy season and the generator fuel budget was a serious monthly conversation. Her mother sold fabric at Balogun Market, up before 5 every morning, back after 8 every night, standing on concrete floors in the Lagos heat for 14 hours so that her children would not have to. Claire's school, Sunshine Secondary School, Ajegunle, had its law and debating program collapse 3 years ago. No funding, no qualified teacher to sustain it. The school had 1 set of law textbooks shared between 4 classes, their spines cracked, their pages marked up in 3 different handwriting styles by 3 different students who had passed through before Claire arrived. But here is the thing about Claire Adeyemi. She was not waiting for anyone to hand her anything. She taught herself. Borrowed books from the Lagos State Central Library on Lagos Island, 2 bus rides each way. Printed court judgments from a cyber cafe on Wharf Road for 20 naira a page, and carried them home in a plastic nylon bag. She read Supreme Court rulings the way other teenagers consumed music, obsessively, repeatedly, until the language stopped being foreign and started being hers. Her notebook, A thick A4 exercise book she bought in bulk from a stationery shop near her mother's market stall was filled with case summaries she had written herself, legal arguments she had constructed from scratch, dissenting opinions she had drafted on cases where she thought the court got it wrong. No law lecturer had ever reviewed that notebook because she had not yet entered university. She was finishing her first year at Lagos State University, Faculty of Law, that the legal establishment regarded the way you regard a cousin who showed up to the wedding without an invitation, technically allowed, but noted. So how did she end up at the Nigerian law school competition hall? Her mother's customer, a woman named Mrs. Blessing Okoye who bought Ankara fabric from Doris every Thursday and sometimes stayed to drink tea and talk. Mrs. Okoye's son was a second-year law student at Unilag, who had competed in the Invitational the year before and not made it past the first round. He had left the competition flyer on his mother's kitchen table. Mrs. Okoye brought it to the market, folded inside a newspaper, and handed it across the bolt of fabric to Doris. "I heard your daughter is the sharp one," she said. "This is free to enter. Any Nigerian law student can register." Doris brought the flyer home that evening and set it in front of Claire at the dinner table without a word. Claire read it twice. Then she looked at her mother. "They will not expect me," she said. Doris looked back at her daughter with the expression of a woman who had been exceeding people's expectations since she was 17 years old. "Good," she said. "Go and remind them." That Saturday morning, Doris woke up at 4. She ironed Claire's clothes the night before. A white blouse, dark trousers, a fitted navy blazer Claire had borrowed from her auntie in Sur-Hilaire. She pressed the blazer twice, laid it flat over the back of a chair, and left a note on top of it that said simply, "You are ready." Doris could not come to watch. Saturday was market day. The fabric stall could not be closed. The twin brothers needed feeding. The rent was 2 weeks away. Real life does not pause for even the most important moments. So Doris went to market at 5 in the morning, and Claire took a danfo from Ajegunle to Lagos Island alone. She arrived 45 minutes early. She walked into the registration lobby by herself. The volunteer at the check-in table looked at her institution, Lagos State University, and then looked at her again, the way people look at something that doesn't match the pattern they were expecting. "Lashu," the volunteer said. Then, quieter, with a different kind of polite, "Are you sure you're registered for the right event?" Claire said yes. Clearly, without rushing the word, without adding anything to soften it or explain it. Just, yes. The volunteer shrugged and handed her a number badge. Number 47. When she entered the competition chamber and sat down, the seats around her filled up one by one. The row in front, the row behind, the seat to her left, but the seat to her right stayed empty for the entire pre-competition briefing, as though the air around her had a fence around it that no one wanted to climb. She didn't look at the empty seat. She opened her notebook under the desk and read through a legal argument she had drafted back in March, 4 months before she knew this competition existed. An argument about the burden of proof in constitutional rights violations. She had written it at midnight at the kitchen table while her brother slept and her mother's radio played lowly in the next room. She had written it for no one, for nothing, for the pure need to put the argument somewhere outside her own head. She had been waiting for a room that could understand what was in that notebook. She just didn't know the room would try this hard to keep her out. The competition began at 9 in the morning. Professor Richard Harmon stood at the podium, adjusted his lapel microphone, and welcomed the room. 44 contestants, he said, the finest young legal minds in this country. He paused for exactly long enough to let the compliment settle. This competition demands precision. It demands depth. It demands the kind of rigorous legal formation that separates serious advocates from. He let his eyes move across the room slowly, landing briefly on Claire's section. Enthusiasts. A few people in the audience smiled. They understood the geography of that pause. The qualifying round format was straightforward. 3 moot problems, 90 minutes total. Each problem was a simulated legal scenario requiring written submissions, identify the issues, apply the applicable law, construct the argument, reach a conclusion. Show all reasoning. Official competition stationery only. No personal notes. No external materials. No case law printouts from your own research files. That last rule. A proctor moved down the aisles collecting everything that wasn't issued by the competition. When he reached Claire's desk, he lifted her A4 notebook, the one with 4 months of self-taught case law analysis, the one she'd carried on 2 buses from Ajegunle to Lagos Island, the one that was her entire arsenal, and dropped it into a plastic bin without looking at it. Claire watched it go, her jaw tightened. For the first time since she walked into that building, something that lived near fear moved across her face. But then the problem sheets landed on her desk. 3 pages, stapled at the corner. The scenarios projected on the screen at the front of the chamber so the audience could follow along. Claire picked up the competition pen, read Scenario 1, and started writing. Her handwriting was neat, fast, economical. Not beautiful, efficient. She moved through the first problem like she had argued it before. Like the issues had already been organized inside her head, and all she was doing now was transcribing them onto paper. First the procedural issue, then the substantive, then the remedy. Then one line at the end that anticipated the counterargument and dismantled it in advance. Problem 2, the same way. Problem 3, she paused for 11 seconds. A parent in the audience actually counted they mentioned it afterward. And then she kept writing. By the 40-minute mark, most contestants were still deep in problem 2. A few were sweating. One had crossed out an entire paragraph. Claire was reviewing problem 3. A professor from Unilag seated in the audience leaned toward the colleague beside him and said, quietly, "Who is that?" Nobody answered because nobody knew. The contestant everyone expected to win was 3 rows to Claire's left. His name was Philip Osi Bonsu, 20 years old, Pemberton Academy, Abuja. Now at the University of Lagos Faculty of Law, already being called by some in the legal community the most naturally gifted advocacy student in a generation. His father was a retired high court judge. His mother sat a senior advocate. Philip had been arguing law since he was 14 at the dinner table with 2 sand-parents on the other side of the argument. He had done this competition before and made the final round. He was the reason several people in the audience had driven in from Abuja. Philip glanced at Claire once when she sat down. Then he returned to his own desk, not dismissively, simply. The way you return to your own lane when you're already moving at a speed you're comfortable with. Claire did not glance at Philip. She was reading her answers back over her own work. Here is where the story became something more than a competition. Problem 3. The third scenario in the qualifying round. It involved a constitutional law question about the right to fair hearing under Section 36 of the Nigerian Constitution, applied to an employment tribunal ruling. The scenario as written described the tribunal making a decision and then cited a section of the Evidence Act that did not apply to tribunal proceedings. The citation was wrong, not slightly wrong. Foundationally wrong. The section cited governed criminal proceedings in the High Court. It had no jurisdiction over the administrative tribunal described in the scenario. If you applied the cited section as written, the entire legal analysis collapsed. The argument became impossible to construct coherently. The problem, as stated, was built on a broken foundation. Claire read it once, then twice. Then she set the pen down for a moment, the way a person sets something down when they need both hands free to think. She read it a third time. There it was. She looked up at the projected screen. The same wrong citation visible to 400 people. 43 other contestants working through it. Not one of them had stopped. She looked back down at her paper. She had 22 minutes remaining. She could skip it, move on. Argue around the broken citation as though it were correct. Many of the other contestants were already doing exactly that, because that is what you do when you've been trained inside a system. You trust the system's materials. You don't question the premise. You answer the question. Claire Adeyemi had not been trained inside this system. She had no reason to assume the system was always right. She finished her submission for what the problem should have been. The corrected version, citing the correct section of the Evidence Act, the one that actually governed administrative tribunals, built the argument on that foundation and set her pen down with 4 minutes still on the clock. She sat with her hands flat on the desk, watching the timer count down, calm. The timer reached 0. Pens down, proctors moved through the rows collecting submissions. Harmon stood at the podium and announced that results would be reviewed by the panel. The top 18 would advance to the semifinal round. But first, he opened the floor. If any contestant has a procedural question about the scenarios, now is the time. Silence. 43 contestants sat there. Some looked relieved, some looked drained. A few were already doing the quiet arithmetic of whether they had done enough. Nobody had anything to say, nobody except Claire. Her hand went up, steady, not hesitant. Harmon's eyebrows rose. He looked at her the way you look at something that has interrupted your perfectly organized morning. Yes, he said. The contestant from? He checked his sheet, Lagos State University. He said it the way you'd say the name of a street you'd never driven down. A few people in the audience shifted. The air in the room changed, just slightly. The way air changes before weather. Claire stood up. She did not rush. She spoke clearly, at a volume the room could hear without effort. Scenario 3, Professor. The Evidence Act citation. Harmon tilted his head. What about it? Cite it. The Section 83 applies to criminal proceedings in the High Court. It does not apply to administrative tribunal proceedings. The scenario describes a tribunal. The citation as written has no legal force in that context. The room shifted. You could feel it before you could see it. A tightening. A leaning forward. Harmon's face did not move. I'm aware of what I wrote. Then you're aware the argument cannot be coherently constructed from that foundation. 400 people. Not a sound, Claire continued. Her voice was not raised. It was not performative. It was the voice of someone stating a fact they had verified before opening their mouth. The correct section for tribunal proceedings under the Evidence Act, as read with the Federal High Court Civil Procedure Rules, would govern admissibility differently. If you apply that section instead, the analysis resolves cleanly. I constructed the argument from the corrected foundation. The submission is complete. She sat down. The silence lasted 4 full seconds. Then the murmuring began. Harmon looked to his right. Dr. Sandra Leigh was seated there, a visiting panelist, professor of constitutional law at the London School of Economics, Nigerian-born, one of the most respected international law scholars of her generation. She had a reputation for being meticulous, impartial, and genuinely impossible to impress. Dr. Leigh was already checking something on the tablet in front of her. Her fingers moved. Her eyebrows lifted fractionally. She looked at Harmon and gave one small nod, almost invisible. But Claire saw it. And so did anyone who was paying attention. Harmon cleared his throat. A citation discrepancy will be taken into account during the scoring process. That was it. Nothing else. No acknowledgement. No good catch. No, that is a significant observation. He moved on immediately, the way you move past something you would rather not have happened in front of witnesses. But here is what everyone in that chamber understood, even if they did not say it out loud. A 19-year-old law student from Ajegunle, in her first year at a state university, had just identified a foundational citation error in a scenario written by a 30-year senior advocate of Nigeria. The man who created this competition, who had been writing its materials for 22 years, and she had explained, precisely and publicly, exactly what was wrong and exactly how to correct it, and he could not even say thank you. The audience noticed. The murmuring spread low and fast, the way news travels in a room full of people who understand what they have just witnessed. Phones came out. The live stream chat, which had been moving slowly through the qualifying round announcements, suddenly accelerated. Dr. Sandra Leigh had not moved from her seat at the end of the judge's bench. She had been quiet all morning. She sat the way people sit when they are collecting information and do not yet need to spend it. She looked at Claire for a long moment after the room returned to procedural business. Then she reached across the table and picked up Claire's qualifying submission from the stack that had been passed to the panel. She read it, not skimmed it, read it, made several annotations in the margin with a red pen, and set it apart from the other submissions on her left side. Her face gave nothing away, but she kept that submission separate. 20 minutes later, the qualifying results appeared on the screen at the front of the chamber. Claire's name was there. She had made the top 18, but the number beside her name was not what she had earned. Here is what Harmon did. Instead of acknowledging that Claire had correctly identified the citation error and crediting her for submitting the only logically coherent argument built on the corrected foundation, he removed Scenario 3 from the scoring matrix entirely. All 44 contestants were rescored across 2 problems instead of 3. Claire had submitted flawless work on all 3. Her advantage, the only perfect submission in the room, was erased. She dropped from first place to 11th, still qualifying. But stripped of what she had earned, if you look carefully at the scoreboard, you could see it. 11th place. And you could also calculate, if you knew what had happened, that she should have been first. There was a man in the back of the room who did that calculation in under 30 seconds. His name was Marcus. 26 years old, Claire's older cousin. He had taken a half-day off work at the construction firm, where he was a site supervisor, ironed his best shirt that morning, and taken 2 buses to Lagos Island to watch his little cousin walk into a room that had never seen anything like her. Marcus stood up when the scoreboard appeared. His hands were at his sides clenched. He took half a step toward the aisle. Then he caught Claire's eye from across the room. She shook her head. One small movement, almost invisible. Not now. Marcus sat back down. But his eyes stayed on Harmon. Claire looked at the scoreboard one more time. 11th. She blinked once. Then she turned away from it and started reading the briefing materials for the semifinal round. The qualifying round was just the beginning. The semifinal changed everything. No more written submissions at individual desks. The semifinal was live, oral, and staged. 2 contestants assigned to the same case, arguing opposite sides in front of the full chamber, in front of the panel, in front of 400 people and a camera crew. Every word audible, every hesitation visible, every weakness exposed under the full and unforgiving light of a room that had not come to be kind. 18 contestants, 9 matchups, 20-minute clock per round. Best oral advocacy wins. Claire's first opponent was a second-year student from the University of Ibadan, sharp, polished, well-prepared. She had clearly done this before. She walked to the podium with the ease of someone for whom performance was not an added layer on top of substance. It was integrated. She was assigned the applicant's side. Claire was assigned the respondent. The case appeared on screen. A constitutional challenge to a government procurement policy. The Ibadan student opened her argument with a strong citation sequence, organized, rhythmic, building her case brick by brick. The audience nodded along. A few panelists made notes. This was what they expected. Clean, competent, experienced. Then it was Claire's turn to respond. She stood at the podium. She looked at the panel once, then at the problem on the screen, then back at the panel. She began not with the strongest argument, but with the weakest one, her opponent's weakest one. She dismantled it in 45 seconds. Brief, surgical, no theater. Then she moved to her own submissions. What happened over the next 12 minutes made the room change temperature, because Claire did not argue the case. She reframed it. She took the constitutional challenge her opponent had presented and showed the panel that the challenge, correctly interpreted, was not a procurement dispute at all. It was a separation of powers question. And once it became a separation of powers question, the entire legal landscape shifted, the precedents shifted, the applicable remedies shifted, and the respondent's position, her position, became significantly stronger. The Ibadan student was well prepared for the case as written. She was not prepared for the case as reframed, the proctor called the result. The audience wasn't murmuring. They were watching. The second semifinal matchup was announced. Claire Adeyemi versus Philip Osi Bonsu. When the names appeared on the screen together, the room reacted before anyone could organize their reaction. A current ran through the audience the way it runs through a crowd when the right 2 people finally face each other in the ring. This was the matchup. The Unilag Golden Boy with the judge's surname and the Pemberton pedigree, against the girl from Ajegunle who had identified a citation error in front of his audience, on his stage. Philip walked to the podium with the composure of someone who had been preparing for this moment since he was 14. Not this specific moment, but this category of moment. High stakes, live performance, something real on the line. He was assigned the applicant's side. Claire, the respondent again. Before they began, Harmon made an announcement. The semifinal round would incorporate a challenge format. After each contestant delivered their submissions, the opposing counsel would have 90 seconds to identify a material flaw in the argument or present a superior legal path. If the challenge was substantively valid, the challenging counsel would receive an additional point. A few people in the audience flipped through the printed competition booklet. Another turned the pages. Someone held theirs up to the light, squinting. The rule was not in the booklet. One of the junior panelists, Dr. Emmanuel Chukwu, a constitutional law lecturer from Unilag, leaned toward Harmon and said something quietly. Harmon put one hand up and said nothing further. Dr. Leigh, at the far end of the bench, wrote something on her notepad. The problem appeared on screen. Philip began. His oral argument was precisely what you would expect from someone raised between a judge's library and a senior advocate's briefing room. He cited seamlessly. He structured his argument in the classical 3-issue format: jurisdiction, substantive rights, remedy, moving through each with the fluency of someone for whom legal language had been mother tongue since childhood. His eye contact with the panel was steady. His voice modulated exactly right. He finished with 2 minutes remaining and received a round of measured, respectful applause from the audience. Then Claire's challenge window opened. 90 seconds. She stood up. She did not attack Philip's argument. She did not search for an error. She said the argument is legally sound. Philip blinked. A few people in the audience glanced at each other. The structure is correct, Claire continued. The citations are accurate. The conclusion follows from the premises. She paused. But the argument assumes the tribunal had jurisdiction to make a costs order. It cites 3 authorities for that proposition. All 3 are high court decisions. Another pause. An administrative tribunal cannot derive jurisdiction from high court authorities. The jurisdiction question needed to be resolved first from the enabling statute before the cost argument could be built. The argument as presented is sound in substance and deficient in sequence. She sat down. Philip stared at the panel table. then at Claire, then at the panel table again, because she had not been wrong. And the thing about Philip Osibansu was that he knew, immediately and without negotiation, when he had encountered something he had not prepared for, the judges conferred. Dr. Chukwu was nodding. Dr. Leigh had written something and underlined it the result. Challenge upheld. Additional point to Adeyemi, the bracket for the final round appeared 10 minutes later. Claire read it. Then she read it again. The final round was not contestant against contestant. It was called the exhibition advocacy, a tradition Harmon had instituted 5 years ago. The last contestant standing did not face another student. They faced a problem selected personally by the judging panel. In practice, that meant one thing. Claire would be arguing a case handpicked by Richard Harmon, the same man who had compared her to something not worth noticing, the same man who had erased her perfect qualifying score. And she would be doing it alone, on stage, in front of 400 people, and a camera crew, and a live stream that had been climbing steadily since her semifinal challenge. She had 45 minutes to prepare. The preparation room was a small office on the second floor of the building. A desk, a chair, a stack of approved reference materials, published law reports, approved textbooks, copies of the Nigerian Constitution and relevant statutes. No phone, no personal notes, no outside help. Claire asked for her A4 notebook. The one in the plastic bin downstairs, the proctor checked with the judge's table. The answer came back in under 15 seconds. Competition materials only. Claire closed her eyes for 1 second. Then she opened them, sat down at the desk, and pulled the reference materials toward her. She did not start with the textbooks. She pulled the last 4 years of exhibition advocacy problems from the stack. They were included in the competition archive, available to all finalists. She read through each one, not to memorize the answers, but to map the pattern. Because Claire had done something in the weeks before this competition that no one in that chamber knew about. She had read Richard Harmon's published work, all of it, his 3 legal textbooks, available in the Lagos State Central Library, his published articles in the Nigerian Law Review and the African Journal of International Law, accessed through the Cyber Café on Wharf Road for 20 naira a page. His known positions on constitutional interpretation, on the burden of proof in administrative law, on the limits of judicial review. She had read him the way a chess player studies an opponent's recorded games, not to copy the moves, but to understand the architecture of the mind making them. Harmon had a signature approach. She had identified it across multiple texts. He favored arguments that appeared to have one center of gravity, but actually had 2. A visible main argument and a structural supporting argument that most readers missed because it was embedded rather than stated. He liked complexity that looked like simplicity on the surface. His hardest problems shared a design principle. They presented a case that seemed to be about one right, when it was actually about the interaction between 2 rights in tension. She had mapped this pattern on 6 pages of competition paper, decision trees, if-then branches, alternative argument sequences depending on which version of the problem appeared. Then her phone, which had been taken at check-in but placed in her jacket pocket by a proctor who had missed it, buzzed once in her inside pocket. A message from her mother. Market is slow today. I keep thinking about you. Your grandmother says to tell you. The voice they cannot silence is the one that was never trying to shout. Go well. Claire stared at the screen, her composure held, but only just. Because her grandmother had been gone for 3 years, and Doris still carried her words like they were still being spoken, passing them on to Claire at the moments they were most needed. The grandmother who had cleaned houses in Victoria Island for 30 years so that Doris could go to school. The grandmother who told Claire when she was 9 years old, "They will try to tell you the room is not for you. Walk in anyway. The room does not get to decide." The weight of it. Her mother at the fabric stall, her brothers at home, her grandmother's voice arriving through a message on a screen, pressed down on Claire all at once, and for a moment the composure cracked. Not visibly, but inside something shook. She put the phone away. She went back to her frameworks. She was circling one pattern in particular, a structural fingerprint she had found in Harmon's second textbook and in 2 of his published articles. A tendency to construct his hardest problems around a scenario where the obvious legal remedy was available, but applying it created a secondary violation, a trap built into the problem's architecture. A hidden cost in the obvious answer. If he used that structure today, she would recognize it. She circled it twice and pressed the pen in hard. The walls of the preparation room were thin, and through the thin wall, she heard 2 voices in the corridor. One of them was Philip Osibansu. He was speaking to someone she could not identify, his voice carrying the measured tone of someone making an observation, not a boast. "She's been impressive," Philip was saying. "I'm not taking anything away from what she did in the semi. That challenge was legitimate." A pause. "But the exhibition advocacy is built differently. Professor Harmon designs those problems specifically around the frameworks he teaches in his advanced seminar. The authorities he uses, the way the facts are constructed. It maps directly to his teaching methodology. If you haven't studied under him, there are structural elements in those problems that don't get read the same way. He wasn't being cruel, he was being analytical. The way someone who has grown up inside a system reasons about it. Not because they are trying to exclude anyone, but because to them, the system's logic is simply the way the world works. She's had a good run," he continued. "But this is where the design catches up." He wasn't wrong about how the problems were designed. He just didn't know that Claire had read everything Harmon had ever published. She sat very still for 10 seconds. Then she pressed the pen harder into the page and kept working. She didn't change anything she was doing. While Claire prepared in the small room on the second floor, the competition hall below was transforming. The live stream viewer count had more than tripled since the semifinal. Someone in the audience had recorded Claire's challenge on their phone. The moment she stood up, identified the jurisdiction sequencing flaw in Philip's argument, and sat back down in under 2 minutes, and posted it to Twitter with the caption, "This girl from Lasso just did what at the Harmon-Briggs Moot? Watch this." It had been shared several hundred times and was still moving. A journalist from one of the legal news platforms had pulled up Claire's registration details and was trying to find someone who knew her background. A law school administrator nearby overheard and said, carefully, "First-year student. Lagos State. No prior competition record." The journalist looked at her phone, then looked at the administrator. "First year?" The administrator nodded. The journalist wrote something. At the judge's bench, Dr. Sandra Leigh had not moved from her seat. She had Claire's qualifying submission in front of her, the one she had set apart that morning. She was reading it for the second time. She made 3 additional annotations in the margin. Then she opened a separate notebook, her own, not the competition's, and wrote something in it. 3 lines. She closed the notebook and set it beside her. Her face gave nothing away. But she closed the notebook on those 3 lines as though they were important enough to keep. Philip Osibansu had returned to the main hall and taken a seat in the front row. He was not looking at his phone. He was looking at the empty stage at the front of the chamber. His expression had settled into something quieter and more genuine than anything he had worn that morning. He was thinking. The kind of thinking that happens when you've encountered something that didn't fit the category you had prepared for it. Back in the preparation room, Claire had 5 minutes remaining. She reviewed her 6 pages of frameworks one last time. She thought about the pattern she had circled, the hidden trap, the obvious remedy that created a secondary violation. If he used it, she was ready. If he didn't, she would adapt. She was always going to walk back into that room. A knock on the door. "Miss Adeyemi, time." Claire stood up. She straightened her blazer. She touched the collar of the white blouse her mother had ironed the night before. A quick, private gesture, there and gone. Then she walked back into the competition chamber. 400 people turned to look at her, plus the camera crew, plus the live stream audience, now approaching 4,000. The journalist who had been asking questions had her phone raised. Recording, every eye in the room was on Claire Adeyemi when she walked to the advocacy podium. The problem appeared on the massive screen behind the judge's bench. Claire read it. Her face did not change. But inside, something clicked into place like the final piece of a structure she had been building for weeks, because the problem, the one Harmon had personally selected to end her run, was constructed exactly as she had mapped, not identically. Harmon was too precise for that. He had dressed it differently, wrapped the core structure in an additional layer of statutory complexity she had not fully anticipated, introduced 2 facts that required careful sequencing before the main argument could be constructed. He had made it harder than his published work. Harder than anything in the archived exhibition problems. But the skeleton, the hidden trap, the obvious remedy that created a secondary violation, was there. She had drawn that skeleton on competition paper in the room upstairs. She had circled it twice. She looked at the problem for 7 seconds. Then she picked up the advocacy pen, opened her notepad, and the room held its breath. The first 10 minutes were what the audience expected from a strong contestant. She identified the legal issues clearly. She established the applicable statutory framework. She cited 3 relevant authorities, 2 from the Nigerian Supreme Court and 1 from the Court of Appeal, all cited correctly, all directly on point. Her voice was measured and precise. She was building the argument the way you lay a foundation, not because the foundation is the interesting part, but because everything that comes after depends on it. Harmon sat at the center of the bench with his pen moving steadily. Philip in the front row was watching her the way he had watched the chalkboard during a difficult proof. Not critically, just completely. Then Claire stopped. Not because she had reached the end of her argument, because she had found something inside the problem. Her pen stopped moving. She stood at the podium, looking at the notepad in front of her, and her eyes went still. Moving left, then right. Reading what she had written, she did not move. 10 seconds. 20, the live stream chat began to accelerate. She's stuck. This is where it ends. Called it. The comments scrolled faster than people could read them. Harmon checked his watch. The thin expression appeared on his face. Not quite satisfaction. Something closer to the quiet relief of a man watching a prediction organize itself into fact. Here is what had happened. Claire's argument had been moving correctly through the framework she had anticipated, the hidden trap, the obvious remedy creating a secondary violation. She had seen it and navigated around it, presenting a path that avoided the trap and reached the correct conclusion. Her framework had held, but 12 steps into the argument, she had found something else, something Harmon had not written in any of his published papers. A second layer, a secondary statutory provision embedded in one of the facts that interacted with her chosen remedy in a way that created a new complication. Not the trap she had prepared for. A different one, buried deeper. Visible only from inside the argument, only once you were 12 steps in and had committed to a direction. It was like walking through a room you had mapped from the outside and discovering that the room had a wall that didn't appear on any map. Her method was still correct. Her logic was sound. But she needed one more step, one connecting thread between where she was and where the argument needed to land, and that thread required her to synthesize 2 provisions she had never seen placed in direct conversation with each other. She had played with the idea, alone in her notebook, in the margins of printed court judgments at 2 in the morning. She had felt the connection between those provisions without ever formalizing it, without ever testing it in public, without ever finding out if it actually held. Now she had to find out on stage in front of 400 people. The chalk of it, the pen, in this case, hung in the air. Harmon leaned into his microphone. His voice was gentle, deliberate, calibrated. Miss Adeyemi, a beat. Do you wish to continue, or would you prefer to concede the round? He let the next sentence arrive slowly. There is no shame in recognizing the limits of one's preparation. The room absorbed it. The gentleness was the instrument. He was not mocking her. He was offering an exit. The kind of exit that looks like compassion and functions like a door being closed from the outside. A 19-year-old. First year. Ajegunle. Of course she ran out of road here. Of course this is where it ends. She gave it a remarkable run. But she has now met the limit. A few people in the audience looked away. Claire's pen dropped to her side. She stood at the podium looking at the notepad in front of her, at the argument that was so close to complete and so precisely one thread short. She looked at the audience. 400 faces. Most of them already writing the ending in their heads. The story they would tell tonight, over dinner, over the phone. There was this girl from Ajegunle, first-year student. She was extraordinary for most of it. But the final problem was designed for someone who had trained under Harmon, and in the end, that's where it caught up with her. Then she looked at the back of the room. Marcus was there, her cousin. Half day off work, 2 buses, best shirt. He had not moved, had not stood, had not done anything external. He was just sitting there, looking at his little cousin the way he had looked at her since she was 12 years old, and had told him she was going to argue in front of the Supreme Court one day. And he had said, without blinking, "Okay, you'll need to know the procedure rules. Let me find out what those are." He didn't nod at her. He didn't need to. Then from the judge's bench, Dr. Sandra Leigh spoke. One sentence, no inflection, pure fact. "The clock has not expired, Miss Adeyemi. The floor is yours." Claire looked at her. Dr. Leigh looked back. Nothing passed between them except the sentence. And the sentence was enough. The door is still open. Claire turned back to the podium. She picked up her pen. She looked at her notepad, at the 12 steps of argument she had constructed, at the thread she needed and had not yet formalized. And then she set the notepad aside. She did not abandon her argument. She did something different. She looked at the panel and she said, "I need to take the argument in a different direction." She started again, not from the beginning. From a different angle entirely. She went to the secondary statutory provision, the one she had found buried in the facts, the one that had created the complication, and she made it the center, not the complication, the foundation. She reframed the entire case. What had been an argument about the right to fair hearing, the obvious primary right at the center of the scenario, became an argument about the relationship between administrative due process and the enabling statute's scope of authority. A different question, a harder question, a question that Harmon had embedded in the facts without expecting anyone to extract it. Her voice changed, not louder, faster, looser, the way writing changes when someone stops performing and starts thinking. She was building the argument in real time, in public, with everything on the line, and what she built over the next 9 minutes would change the way Professor Richard Harmon thought about legal problems for the rest of his life. She began with the specific case, the scenario as written. She restated the facts cleanly, one paragraph. Every material fact, nothing extraneous. Then she introduced a single recharacterization. She said, "The question is not whether the right to fair hearing was violated. The question is whether the tribunal had statutory authority to conduct the proceeding that produced the alleged violation in the first place." Silence. One panelist, Dr. Chukwu, sat forward. Because Claire had just done something that took most lawyers years to learn how to do. She had attacked the jurisdiction before the merits. She had gone upstream. She was arguing that the entire proceeding was void, not voidable. Void, because the tribunal had exceeded its enabling statute, which meant that the fair hearing question didn't need to be answered at all, because there was no valid proceeding in which a hearing could have occurred. She cited the enabling statute. She cited the specific section that defined the tribunal's scope. She cited 2 Supreme Court authorities on the principle of jurisdictional excess in administrative law. All 3 cited correctly. All 3 directly on point. Philip Osi-Bonsu, front row, was shaking his head slowly. Not in disagreement, in recognition. "She's not arguing the case," he said quietly to the person beside him. "She's pulling the floor out from under it." Dr. Leigh's pen was moving. She was writing without looking at the page. Harmon's pen had stopped. Claire reached the argument's apex. The tribunal had exceeded its statutory authority. The proceeding was therefore void. The fair hearing question, the question the scenario appeared to be asking, did not arise because there was no valid proceeding in which it could arise. Then she went further. She said, "But I want to address the subsidiary question. Assuming, without conceding, that the tribunal's proceeding was valid, here is why the fair hearing right was nonetheless not violated. And here is why that analysis changes entirely when the enabling statute's scope is correctly understood." She built the alternative argument, the secondary position, the argument that answered the question even if the primary position failed. Every step followed from the last. Every citation connected to the next. There were no loose ends, no rhetorical excess, no performance, just architecture. When she finished, the argument was not complete. It was comprehensive. She set the pen down. She looked at the panel. "The scenario presents a fair hearing problem," she said. "I've argued that it is actually a jurisdiction problem. And the jurisdiction problem, once resolved, makes the fair hearing analysis either unnecessary or significantly more straightforward than the scenario appears to suggest." She paused. "Those are my submissions." The silence was the kind that has physical weight, the kind that presses against the chest before it releases. Harmon sat at the center of the bench. His pen had not moved for the last 6 minutes. He was looking at the problem on the screen, then at Claire, then at the problem again. The expression on his face was not the expression of a man watching a prediction confirmed. It was the expression of a man who had just discovered something in a room he thought he knew perfectly. Dr. Leigh set her pen down. She looked at her scoring sheet. She wrote one number. Then, next to it, one word. She would not share what she wrote until the result was announced, but Philip Osi-Bonsu, who was close enough to see the sheet's edge from the front row, saw Dr. Leigh underline what she had written. The applause began with one pair of hands. Dr. Emmanuel Chukwu, who pushed his chair back and brought his palms together slowly, once, twice, the sound like a heartbeat finding its rhythm. Then a woman in the second row stood up. Then a cluster of law students in the back. Then the whole room, standing, the sound building and building, the camera crew recording, the live stream chat accelerating into something moving too fast to read. Philip Osi-Bonsu was on his feet before the applause had fully built. He was clapping with both hands and his full attention, and whatever complicated thing the morning had been between them, the matchup, the challenge, the weight of their different starting points, was gone. He had been in the room. He knew what he had witnessed. Marcus in the back row had his elbows on his knees and his face in his hands. His shoulders were moving. He was not clapping. He was trying to hold himself together in the best possible way and not entirely succeeding. But Claire was not looking at the audience. She was looking at Professor Richard Harmon, the only person at the judge's bench who had not yet moved, who was still seated, still, his hands flat on the table surface, 400 people standing and applauding around him. She did not smile. She did not gesture. She did not perform any of the things you can perform when you have won. She simply looked at him, the man who had compared her to something not worth his time, the man who had erased her perfect qualifying score, the man who had offered her, with deliberate gentleness, the opportunity to concede her own excellence. She looked at him and she waited, not for applause, to be seen, because this was never about winning a competition. It was about being seen by the very people who had decided, before she opened her mouth, that there was nothing to see. She was not going to look away until he looked back. The applause was still full in the room when Dr. Sandra Leigh stood for the second time that day. The room quieted before she reached for the microphone. People could read a room correctly when they needed to. Break times? Before we announced the official result, Dr. Leigh said, "I need to place something on the record." Harmon looked at her. Something moved across his face. Not anger. Something more honest than anger. Dr. Leigh reached into the folder beside her on the judge's bench. She removed a single document. She held it up. "This is the original qualifying score sheet from this morning's first round, before any adjustments were made to the problem matrix." She read from it. Slowly, every syllable distinct. Contestant number 47, Claire Adeyemi, Lagos State University, qualifying score, 3 from 3, perfect score. The room went very still. This score was not reported to the public. Scenario 3 was removed from the scoring matrix, and all contestants were rescored across 2 problems only. Miss Adeyemi's ranking dropped from 1st to 11th. Dr. Leigh set the document on the table. For the record, Miss Adeyemi was the only contestant to identify the citation error in Scenario 3. She was also the only contestant to submit a legally coherent argument built on the corrected statutory foundation. She paused. Both facts were omitted from the published results. The murmuring in the room was not the polite, academic murmuring of earlier in the day. It had more heat in it. A woman 3 rows from the front said, "You're serious?" at full conversational volume. A journalist was typing on a phone. The live stream chat was climbing. Dr. Leigh turned to face Harmon. Her voice did not change. It did not need to. "I believe the record should reflect the accurate qualifying performance, Professor, for the integrity of a competition that carries your name and has carried it for 22 years. She placed the original score sheet on the table in front of him, a pen resting on top of it. 400 people watched Richard Harmon look at that document. They watched him look at Dr. Leigh. They watched him look at the camera crew in the corner. They watched him look at the room. He picked up the pen. He signed the document. And in the back row, Marcus Adeyemi let out a breath that sounded like it had been held for years. Harmon stood up. The room went quiet the way rooms go quiet when they understand that something final is arriving. Total, immediate, held. He removed his glasses, folded them, set them on the table with a precision that was the only indication that his hands were not entirely steady. Then he looked at Claire. His voice was not the voice of the man who had stood at the podium that morning and made 400 people laugh. It was a different register, lower, slower. The voice of a man who has spent 30 years being certain of things and has just met something that costs him something real to acknowledge. "The argument is valid," he said. He stopped for a moment. "The jurisdictional recharacterization." Another stop. "I did not design the problem for that approach. I designed it to be argued on the merits of the fair hearing right." He paused again. "The jurisdiction argument is both technically correct and analytically superior. It was not the approach I expected." He looked at the judge's bench, then back at Claire. "And the alternative submissions, the subsidiary analysis under the assumed validity, were comprehensive. There are no material gaps." He set both hands on the edge of the table. "This constitutes original legal analysis. I have not seen this precise argument constructed in 22 years of this competition." The room was still, 400 people not moving. Then quieter, not to the room, to her he said, "I owe you an apology, Miss Adeyemi, not for the scoring adjustment, which Dr. Leigh has correctly addressed. A breath. For what I said this morning, and for what I assumed before you spoke." He extended his hand. Claire looked at it. Then she looked at him. She did not rush what happened next. She let the silence sit for exactly as long as it needed to sit. Then she stepped forward and shook his hand once, firm, brief. She stepped back. She did not smile. She did not nod graciously. She did not offer him the performance of forgiveness or the gift of her gratitude. She simply met his eyes and held them, not grateful, not triumphant, equal. The meaning was not lost on anyone in the room. Dr. Leigh announced the result. Winner of the 22nd Annual Harmon-Briggs National Moot Court Invitational, Claire Adeyemi, Lagos State University. Qualifying score restored to perfect. Exhibition advocacy. Original legal analysis. Unanimous panel decision. The third standing ovation of the day. This one was different from the others. The first two had the sound of surprise in them, the catching of breath, the rush of something unexpected. This one had release in it. The sound of 400 people who had been carrying something tight in their chest all morning and were finally allowed to put it down. Philip Osibansu clapped until his palms were red. He did not stop before anyone else. After the ceremony, Marcus found Claire in the corridor outside the competition chamber. He didn't say anything for a moment. He just pulled her into a hug, the kind that doesn't have a preamble or an agenda, the kind that is just someone who loves you and has been watching you from the back row and is relieved, so completely relieved, that he doesn't have the organization for words yet. Then Claire laughed. Not performed laughter, not polite laughter. The pure, flooded, ridiculous laughter of a body that has been running on precision and pressure for 6 hours and has finally been given permission to stop. She laughed into his shoulder, and the laughter shook her whole frame. "I need my notebook back," she said, when she could speak. "That's what you lead with," Marcus said. "It has everything in it." Yeah, he was laughing too, I know. He went to find the proctor. He came back 3 minutes later with the A4 exercise book, slightly bent at one corner from its time in the plastic bin. Claire took it in both hands. She pressed it to her chest for 1 second. Not for the audience, not for the camera. There was no audience or camera in that corridor, just because it was hers. Because every case summary and self-drafted dissent and midnight annotation in that book had brought her to this room, and the room had tried very hard to tell her she didn't belong here. And she had gone ahead and belonged here anyway. 2 weeks later, a letter arrived at the Adeyemi flat in Ajegunle. Doris called Claire from the market at 6 in the afternoon, her voice different from its usual market day register, quieter, careful, the way a voice goes when it is carrying something fragile. "There is a letter," she said. "It has a logo. I didn't open it. I left it on the table." Claire took 2 buses home from campus. She walked through the flat door, put her bag down, and picked up the envelope. It was from the Faculty of Law at the London School of Economics, signed by Dr. Sandra Leigh. A letter of recommendation for the LSE Summer Law Program, fully funded, accommodation included, travel assistance available. The letter described, in precise academic language, the oral advocacy it had witnessed at the Harmon-Briggs National Moot Court Invitational. It described the jurisdictional recharacterization as a demonstration of rigorous and original legal reasoning at a level rarely encountered in undergraduate advocacy. The final line of the letter said, "Miss Adeyemi is not a promising law student. She is a developing legal scholar." The distinction matters. Claire read the letter standing at the kitchen table. Then she read it again. Then she set it down carefully on the table, face up, next to the electricity bill and a receipt from her mother's fabric supplier. Because that is where real life lives. Not separate from the hard things, but right beside them, in the same light, on the same surface. She took a photograph of the letter on her phone and sent it to Marcus. His reply arrived in 4 seconds, just numbers. 2 buses, half day off work. Worth it, she sent it to her mother. Doris replied with a voice note, 38 seconds long. She was at the market stall, and her voice had the noise of Balagan behind it. The hawkers, the generators, the fabric being pulled from bolts. She said, "Your grandmother said they would try to tell you the room was not for you. You walked in anyway. Now they are writing letters." Then the voice note ended because Doris had a customer, and life was already moving again. There is one moment from that day that I keep returning to. Not the standing ovation, not the original analysis. Not even the moment Harmon signed the corrected score sheet in front of 400 witnesses. It is a smaller moment, earlier in the day. The moment when Harmon leaned into the microphone and offered Claire the gentle, public, impeccably worded opportunity to concede. There is no shame in recognizing the limits of one's preparation. And Claire stood at that podium, argument unfinished, room watching, live stream running, and chose not to walk through the door he was holding open for her. She chose instead to set the notepad aside, to say, "I need to go in a different direction," and start again, not from the beginning, from a different angle, a harder angle. An angle no one else in that room had thought to look from. That is the moment. That is the thing I want you to hold, because there is a version of that moment that ends differently, where the gentleness of the offer is the thing that finally breaks the composure, where the room's expectation becomes the wall you can't get past, where the voice that says, "This is where it ends," is the one you believe, because it is coming from the most authoritative person in the room, and he is being so kind about it. Claire Adeyemi did not believe that voice. Not because she wasn't afraid. She was. You could see it for those 20 seconds she stood still at the podium. But she had come from Ajegunle to Lagos Island on 2 buses in her mother's ironed blouse, with an A4 notebook full of arguments she had built alone at midnight at a kitchen table. She had identified a citation error in front of 400 people and been thanked with silence. She had argued a case on a stage designed to make her look like a visitor. She had not come this far to let someone else's gentleness be the thing that stopped her. She put the notepad aside. She picked up her pen. She found a different angle. And from that angle, she built something that nobody in the room had seen coming, including the man who had spent 6 months designing the problem to ensure she never could. Her mother pressed her blouse the night before she knew any of this would happen. Her grandmother gave her voice to a market stall phone call and arrived anyway. A plastic bin on a registration table tried to hold her notebook. It got it back. The room told her it was not for her. She went in anyway. And somewhere in Lagos tonight, in a flat in Ajegunle where the electricity bill is on the kitchen table and the generator runs on a budget, and a fabric seller gets up at 4 every morning so her daughter can take 2 buses to a room she was never supposed to enter, that A4 notebook is on the shelf. And in its margins, between the case summaries and the self-drafted dissents and the arguments constructed at midnight for no audience and no reward, there is the outline of a jurisdictional argument that a 30-year senior advocate of Nigeria had to stand up in public and call original. He built 22 competitions. She built 1 argument, and the argument won. Now I want to ask you something, and I want you to answer honestly in the comments below. Claire Adeyemi walked into a room that was designed, not by accident, but by design, to make her feel like a visitor. The seat beside her stayed empty. The citation error she found was met with silence. The score she earned was erased. And when she was closest to the finish line, the most powerful person in the room offered her the most dangerous thing, a gentle way out. She didn't take it. So here is my question for you today. What is the room that was designed to make you feel like a visitor? And what did you do, or what are you still deciding to do, about the door? Tell me in the comments. Share this video with one person who needs to hear it today. And subscribe to this channel, because stories like Claire's are not rare. They are just rarely told.